Hello, everybody, and welcome to this evening's live webinar. Thanks very much for joining us. My name is Andrew. Elkan is going to come on in a minute. You can see a panel that we've got up there. We're going to introduce those guys to you in a minute as well. But before we do that, I just want to give you an idea of kind of what we're doing here and a bit of an introduction to what we're trying to get, aiming to do tonight. So today's session, or this evening's session, is going to last around 45 minutes. But certainly won't take any longer than an hour. And really, this is a new idea that we've pulled together to help you, our clients, get to grips with where you and the COVID-19 Families for Justice group stand in the whole legal process. If you're already a client or if you're showing interest, you may already be receiving email newsletters from us that are attempting to keep you up to date with where you are. The idea of this is a live session. So we know that when those email newsletters go out, we get asked a lot of questions. So we thought we'd try with some of the panel that are going to be working on this case with you, we try and pull this together in a bit of a live session. So the format is designed to allow you guys to ask us questions. And just to give you a bit of reassurance, and I will repeat this again before we start, if you want to ask a question, you can do. And your identity will be kept anonymous. So no one's going to know it is you that is asking a question. I'll explain in a minute how you ask questions, but before you do, I do that. Enough of me for the time being. Let me just hand over to Elkan, who a lot of you will know, and Elkan is just going to introduce the panel that we have for you tonight. Elkan, do you want to do that for me, please?
Thanks, Andrew. Good evening, everyone. There may be one other person joining us as a barrister called Jesse, and I'll introduce him if he manages to dial in. But at the moment, we have with us Pete Weatherby QC, who is leading the council team, and is a barrister of I don't know how many decades experience. I hesitate to guess. Great experience in public law and civil rights, currently working with me on the Manchester Arena inquiry. Then we have Dr. Oliver Lewis, a couple of decades experience, I think, is that right, Oliver? Again, specialising in human rights, civil liberties, and with a special interest in care homes. And finally, so far, Kate Stone, another human rights barrister of considerable experience, who is based at Garden Court North along with Pete. And then there's me.
Don't forget you, Elkan.
Yeah.
I'm assuming everyone will know who you are, Elkan.
I hope so, but if not, put it in the Q&A and I'll tell you.
Fantastic. Okay. So all of the panelists that you can see today, and we've got one member of technical staff who's helping me run this, we're all bound by the same duty of confidentiality. So basically nothing goes beyond us. Live questions, you can ask those at the bottom of your screen. That you should have three little buttons, and the right-hand side one of those is a Q&A button. So if you have any questions, type your questions in there. Sometimes it gives you the ability to ask anonymously. Click that if you get it. If you don't get that, no one will be able to see who you are when you're asking it. So click that button, type your question, and then I'll basically gather similar questions together, and I'll ask those of the panel once we've gone through some of the popular questions. All questions asked, therefore, are anonymous. No personal details will be shared. If we get lots and lots of questions and I don't have enough time to ask the panel all of your questions within the hour, then we will answer any questions that are not answered during the webinar. We will answer those to you by email in the next week or so. So you will get an answer to your question one way or another. And then at the end, we will have a full list of questions and answers available on our website, certainly all the popular ones. They're on there at the moment. You can find that on the Brody Jackson Cantor website, but all of the questions that are asked and all of the answers that are given will be made available on the website. And then very last thing, when the session ends, you will have an option to take a very short survey, just really to see what you thought of this format. So if you like this new this live newsletter format, we'll go again. If you're not so worried, we'll just continue with the email newsletter. So we'd love to know what you think at the end. So that's all of that over. That's really good. We're keeping to time, which is excellent, 5 minutes in. I'm now going to hand over to the panel, and Elkan's going to start off. And we're just going to give you that kind of live newsletter update. We've got a whole load of bullet points here that we've got to go through. So Elkan, can I hand over to you now? And you can pick that up. If anyone's got any questions as you go in, then great, we've got some coming in already, then I will ask those at the end. So go for it, Elkan. Thank you.
Okay, so first of all, just to think about how we've got to where we are now. We were approached about a year ago by the COVID-19 bereaved Families for Justice, a group of which most, if not all of you are members. If any of you aren't, I'd encourage you to join. And their priority at that time was trying to get an inquiry going. We discussed with them the various formats of inquiries that there could be and reached the conclusion that a statutory inquiry was necessary for reasons which I can go into, but perhaps Pete will mention later when he explains what a statutory inquiry is. And in essence, we in the group have spent the last year trying to A, put pressure on the government, and B, threaten legal proceedings to ensure that the government agreed to set up a statutory inquiry. The problems we met on the legal front on the way was that we first of all asked the government if they would agree not to seek costs against the group if we took proceedings and weren't successful, and the government refused to agree to that. We then asked them how much they'd be asking by way of costs so we could look at fundraising, and they refused to tell us. So the group just started fundraising to set up a legal pot in case they had to pay the costs of the government. It took quite a while to raise enough costs to meet what we thought might be the amount they'd have to pay, and we were thinking of about £100,000. By the time we raised that, we then had to draft paperwork for judicial review, which is a statement of grounds, and that was quite extensive and took quite a while for the barristers in particular to draft. We then got to the stage where we were saying to the government, look, we're now ready to start proceedings, and more or less at that stage, Johnson got up in Parliament and said he was going to hold a statutory inquiry in the spring, or starting in the spring. The question for us then was, is it worth having a judicial review just to argue timing? Now, as it happens, at about that time, another judicial review asking for an inquiry into, I think it was PPA contracting, to be held immediately, failed because, in part, the judge said, it's not our job as judges to interfere with a government decision on timing. So that was a warning shot across our bows, if you like. And we took the view, and we still take the view, that if we went to court now and said, look, he's promised a statutory inquiry, but why can't he start it now? We would lose. So in a way, the legal battle at that stage went into suspension until the actual inquiry proceeding started. And we're now in a position where most of the work is being done by the group on the political front, trying to pressure the government into starting an inquiry earlier. We'll probably discuss later what that means, what a spring start means. So just thinking about other things that have happened now. Shall I turn over to you, Pete? Are you happy to talk about the Cabinet Office talks and the APPG talks?
Sure. Good evening, everybody. I'm Pete Weatherby, as Elkan has mentioned, and some of you have seen me before. The government have not simply chosen to have an inquiry largely into their decisions. They've been driven to it by this campaign primarily, but also through parliamentary action and wider media attention, and probably prompted by the legal efforts that have been made along the way as well, because ultimately they knew that one or all of those forces would require them to face scrutiny. So Johnson started to give in to scrutiny last summer, but it was only on, I think, the 11th of May of this year that he agreed to have a statutory inquiry. I'll come on to why it's so important that it's a statutory inquiry a little later, if I may. But there is a very, very big advantage in having a statutory inquiry rather than some other kind of inquiry that the government makes up simply to make sure they control it. So basically the difference is that a statutory inquiry is likely to be much more effective of taking control of the scrutiny of what has happened and what hasn't happened away from the government. But I'll come back to that in a bit. So I think most of you will be aware of what has happened, and Elkan's touched on it, but the campaign started well over a year ago, and has constantly been a thorn in the side of the government, and that's why we have reached the point that we've got to at the moment. The problem, or the big problem that faces us at the moment, is that although Johnson has conceded that there will be a statutory public inquiry, he has simply wafted in front of you and everybody else the fact that it will start next spring. Now, many of you, quite rightly, have said, well, why do we have to wait yet more months until next spring before we get scrutiny? Actually, I'm afraid there's a further problem, which is that Johnson hasn't indicated and hasn't so far asked our clarification question. What does he mean by next spring? It's one thing if the inquiry starts to hear evidence next spring. It's quite another if they don't do anything until next spring and then put out to consultation what the inquiry should include and who should do it. And so those are the matters that are actually the ones which are most important in the moment at this time. So on the 4th of June, Elkan sent on your behalf a letter which raised a number of issues with the Johnson government, sent it to the Cabinet Office, which is the Department of State responsible for these things. And we raised with them a number of topics. I'll just give you the headlines now, because we'll talk through them over the next hour or so. The first is timetable. It's all very well saying we'll have a public inquiry, but we really need to have some kind of timetable. What is going to happen when? Why haven't they even started, as far as we're aware, to appoint a judge or a panel, or to say when it will start? Secondly, time scale. Some inquiries take many, many years. There's no reason why they should. We want to control the length of it. You want justice, and you want answers, and you want changes for the future, and you want them now. You don't want them in 10 years' time. So time scale is important. Terms of reference. A public inquiry is crafted around scope. Terms of reference are essentially the questions which an inquiry should answer. We produced a draft and we circulated it to as many of the families as possible. And then after a period of toing and froing, we settled and got your agreement on a draft which was sent to the government. They haven't come back to us with any comment about it. But essentially, the questions that we're saying on your behalf that need to be answered are, was the UK prepared for a pandemic? I don't think it would take you very long to answer that. But there are many sort of sub-questions involved in that. And secondly, was the response to the pandemic once it happened, was it effective and was it efficient? And again, that contains a lot of sub-questions about hospitals and care homes and lockdowns and various other matters, and why different parts of our communities were affected differently, and what protection was given to vulnerable people, and etc. The next question we asked them was, who are you going to get to chair it, and will you have a panel? So that's obviously very important in any independent inquiry, that you have people that represent the community, not simply somebody the government appoints to try to keep control and come to a sympathetic series of answers. And we've asked them to consult with us on that. Then resourcing. It's all very well on the 11th of May announcing there'll be a statutory inquiry, but we've said, where's the resourcing? Where's the administration? Who's going to run it? Unless you provide that resourcing now, then the days, the weeks, the months will drift by. Then the next point we've raised with them is effective participation. We have said that you, the families, are at the centre of what has happened, and you should be at the centre of the inquiry. Successful inquiries are only successful where the bereaved, people who've been directly affected, are at the centre of the inquiry. So we're making that very clear to them. We've raised the production and retention of documents and other material. One of the technical problems is that the government have still yet to issue a formal notification which triggers the offences which are committed if someone deletes emails, for example, or shreds documents. They still haven't got around to doing that. And we want them to tell us who's going to manage and how the inquiry is going to be managed. Is it going to be dealt with in a series of topic areas, or is it going to be dealt with in a one inquiry with serial topics one after the other? And finally, we've asked them about devolution, and I'll come on and I'll speak a bit more about devolution. But of course, the pandemic has affected the whole of the UK, but there are 4 nations within it, and there have been decisions which have been taken for the whole of the UK, and there have been decisions which have been taken on a devolved administration basis. So we've raised all of those with the Cabinet Office. They did agree to meet with us, and Elkan and I met with them. I met 2 civil servants, and we had a discussion with them. That was a good start, but they made clear to us that they had no mandate from government to make any commitments to you or to us, and therefore, although they discussed around these issues, they made no commitments to timescale or any of the matters that I've just spoken about. So that's really where we're up to at the moment. We've followed up with a letter to them saying, can we now have a governmental response to those points? It's all very well having a nice discussion and a cup of tea over Zoom with them about them, but unless they make some commitments and some progress, then we'll still be having the same conversation a year from now. That might suit Mr. Johnson, but it certainly doesn't suit you. So that's where we're up to. Elkan, do you want to follow on just about the APPG? And then Oliver, do you want to say something about the recent stuff about the CQC and care homes?
Yes, so as far as the APPG is concerned, that's the all-party parliamentary group on coronavirus. It's a group of MPs from all parties, as the title says, and they do have regular, not frequent meetings, I have to say. And the COVID bereaved group has appeared before them previously. We wrote to them about in particular, the timing of the inquiry, but also the procedure. We had a meeting with a group who advises them, and I think they're offering us a meeting before the APPG itself, but unfortunately they're not going to meet until September. And this was the response to our discussion about how important it was that the inquiry starts as soon as possible was, yes, we understand, we'll try and get you before the committee, but you'll have to wait till September. So I don't get the feeling that even that group appreciates the points we're making about the urgency of bringing forward the inquiry. But if and when we do meet with them in September, it gives us another opportunity for us and the group actually to get publicity and to put a bit more pressure on the government to bring the date forward. And then finally, if I can turn to Oliver on the CQC data just to bring us right up to date.
Thanks very much. Good evening, everyone. So many of you will know that on the 21st of July, the CQC, the Care Quality Commission, which is the regulator of health and social care in England, released data that many people have been calling for some time. And it's data with regard to how many people died per care home from the 10th of April last year until the 31st of March this year. In short, the data is that there were 6,765 care homes that reported at least one death of a resident from COVID between those dates. And in total, there were 39,017 care home deaths over that period. The reaction from the care home sector has been quite interesting, and that many people who run care homes have said how outrageous this the publication of this data is, because just because people died in certain care homes doesn't mean that those care homes are bad care homes, etc., etc. So there have been quite angry Twitter debates that I've seen and resisted participating in. My view is that it can only help with transparency, and people are entitled to know where deaths occurred and how many deaths occurred in each care home, and hopefully that will be helpful to the inquiry and to those members of the groups who've lost loved ones in care homes, because at least you know something now about the numbers of people who died in the care homes rather than knowing nothing. Thank you.
Thanks, Oliver. So should we go back to you, Andrew? I think you were going to start looking at FAQs. You're mute, Andrew.
Apologies, I got too excited. Thanks for that. I was just reading questions that were coming in as you were going through that. So we've got a fair few coming in, guys. So that's great. What I'm just going to do, just to give any more of you that want to ask any questions a bit of a chance, I'm just going to ask, we basically get a lot of very similar questions coming in all the time. So I'm just going to fire the first 6, 7, 8 of those that we're going to do first. I'm going to ask each of the panel to give me 30 seconds to a minute to answer each of these, and then I'm going to crack straight into the questions that you guys are all asking. So do keep putting them in there. There's plenty going on there. So first one, and I think this one's for Pete. Pete, can you just explain, if you haven't already, what is an inquiry?
Yeah, I mean, an inquiry is whatever the government chooses to make it. But a statutory inquiry is an inquiry which is under the Inquiries Act. And the point of that is that it gives the person who's conducting the inquiry all sorts of powers. So a statutory inquiry allows the judge or the panel to require witnesses. So that would include Johnson, Hancock, Javid, whoever else, to come and give evidence on oath in a hearing and be questioned, and hopefully be questioned as well by us on your behalf. And so that's the key thing. It also brings in all sorts of other powers and duties. So if somebody chooses not to turn up or destroys material, they're committing criminal offences. So that's the difference between a statutory inquiry and any other inquiry. The purpose of an inquiry and the purpose of this inquiry is to go through, disclose all the facts, get all the material out into the open, and get a definitive official narrative of what did and didn't happen. So, for example, what happened leading up to the first and second and subsequent lockdowns, why they happened, why they didn't happen earlier. And secondly, to establish accountability. So that's who failed or who omitted to do things which made a real effect. And thirdly, to try to make things better for the future. So the chair of the panel in their report would set out recommendations for real change to be effected, so that people did not suffer and die, do not suffer and die in the future because of the same mistakes that have been made. So that's the purpose, and that's what an inquiry sets out to do.
Thank you. Great. Thanks, Pete. Question number 2 for Elkan. What can an inquiry actually do? Can it determine criminal liability? Can it award compensation?
So just building on what Pete has said, an inquiry inquires into the events. What it doesn't do, and what it's specifically prohibited from doing, is determining criminal liability. It's a little bit confusing because an inquiry could reach certain conclusions from which it's bleedingly obvious that there is criminal liability, but can't actually determine the criminal liability. Similarly, it can't award compensation, and we might have an entirely separate discussion at some point about compensation and compensation schemes and whether some might be brought in and how they might help, but certainly the inquiry itself will not award compensation. While we're talking about inquiries, and just before we get to the next question, we're talking about the chair of an inquiry, and that's a person appointed by a Secretary of State to lead the inquiry. There are two other terms that you might come across: the panel members and assessors. And Pete maybe will want to add to that, but panel members are people who are not necessarily required, but if they are appointed, they sit alongside the chair of the inquiry. The chair is usually, but not always, a judge, and they can be from any background. What we would be arguing is that panel members should be there to lend their life experience and their humanistic understanding, if you like, to the dry legal analysis that the chair will be performing. And again, we'll have to give some thought as to who we should be promoting to sit as panelists, if anybody. But again, ultimately, it's not for us to decide. The assessors, if there are any, are usually experts who are there to help assess the expert evidence and to translate it for the benefit of the chair. I don't know if that, Pete, if that...
that's very important. Can I just add to that? That having a panel is very important, because running an inquiry is quite difficult, and therefore they usually will pick a senior judge, or very often a judge that's just retired. So they don't take them away from other work for a year or 3 years, whatever, however long it takes. So it's judges tend to come from a very narrow section of society, and of course they're judges. They have a narrow view of society, and therefore it's very important that there's a panel alongside them to help them assess the evidence and come to determinations. And it's kind of a jury effect, and it's hugely important that a panel is there to reflect the wider public, you and me, if you like, and different life experience and different backgrounds and genders and heritages and everything else, so that you get as wide a look at everything that has and hasn't happened, and it isn't just left to a lawyer or a judge. So that's the point of it. And we've asked the government to consult with you and everybody else about who the chair and who the panel should be. Ultimately, the minister appoints them, but unless they consult with you, then they will leave themselves open to huge criticism, and that's why we're directly asking them to do that. We're also asking them to do that very quickly indeed, because we don't want to provide them with yet another excuse for delay.
Okay, thank you. Next one, Oliver. How do people get their medical records?
Yeah, so there's a piece of legislation called the Access to Health Records Act 1990. And if you want to see the health records, which are defined as any information relating to the physical or mental health of an individual, then you can contact the organisation that holds those records, whether that's a GP, an NHS trust, private healthcare provider, a care home, etc. If you are that deceased person's personal representative, by which I mean the executor or administrator of the person's estate. So it's important to get that paperwork sorted out, and then you simply write a letter to those organisations requesting the medical records. Always useful to specify from which date you would like the medical records, or you're entitled to receive all of them. So there is provision to do that. Many organisations take a lot of time to reply, and you may have to send reminders. The other way to get medical records, it's slightly more indirect and more clumsy, is if there's an inquest into your loved one's death. Then you, as an interested person in that inquest, and we'll talk about inquests in a minute, may be entitled to their medical information. But I would recommend that you use the procedure outlined under the Access to Health Records Act 1990. And if you just Google that, there's quite a lot of information available online about how to do that.
Can I just add to that, Oliver? A lot of clients, and not just in this case, but generally, clients will write to, say, health authorities and care homes and say, can you please let me have the medical records? I'm the next of kin on your records. Some health authorities will actually provide medical records, but most of them will say, well, no, you can't, you're not a personal representative. And that's immensely frustrating for bereaved families who sometimes have to go through that process when there's no other reason to do it, just to get at the medical records. But I think from what you've said, there's no way around that, is there? No.
There's no way around that, no.
Okay, thanks very much. Number 4, can I have a separate inquest? I think this one's for you as well, Oliver. Can people get a separate inquest to this inquiry?
Yeah, so the inquiry that's going to happen is completely separate from individual inquests that happen after someone dies. So an inquest looks into the specific circumstances of an individual's death, and inquests happen in the coroner's court, local court to where the person died, and the coroner must hold an inquest if the cause of death is unknown, or if the person might have died a violent or unnatural death, or if the person might have died in prison or police custody or in another kind of custodial setting. So what we're finding is that it's quite an uphill battle to get a coroner to open an inquest into the death of someone who's died from COVID, because usually the coroner would think, well, that's the same as someone dying from another illness. It's not unnatural, it's not violent. The cause of death may not be unknown. And so we've all been involved with helping members of the group have an argument with the coroner about this, and we've sort of said that the cause of death is known, or it's very likely to have been COVID, but it's unnatural in the sense that, for example, had lockdown been announced a week or a couple of weeks earlier, the person probably would still be alive, or had testing been available in this person's care home, other residents wouldn't have been discharged from the NHS estate without having had a COVID test, etc., etc. So there could have been actions taken to prevent the death from arising. But those are really, really difficult arguments to make, because there's some quite unhelpful, from our point of view, guidance from the chief coroner about this. So if your loved one hasn't had an inquest yet, then I'm sure that the expert solicitors and advisors at Brodie Jackson Cantor would be able to advise on that, and perhaps provide legal representation if there is an inquest.
Can I just add to that, Oliver, that there's a lot of crossover here. So very often where there have been a catastrophic loss of life, and there's an inquiry, the inquiry will look at everything that an inquest will look at. So if you take the Grenfell fire, or if you take the Manchester Arena bombing as examples, in both of those cases there've been public inquiries, and in both of those cases the inquiries will cover all that a coroner's inquest will cover. And therefore, although technically in law you could then have an inquest as well as the public inquiry, in practice I anticipate in neither of those cases will there be inquests where they look at any evidence or anything like that. The position here, of course, with the massive loss of life, is that it would be quite impossible to look at 150,000, 160,000 individual deaths by COVID. But the public inquiry will look at a lot of the kind of wider issues and the public policy issues that would be looked at an inquest. So Oliver's given the example of lockdowns. So I'm anticipate that that will be a central issue in the public inquiry, and that will deal with all the issues, the general issues around lockdowns. And therefore, the utility of inquests will be where there are specific issues where we can argue with coroners that an inquest will add value to you, the families, and is necessary in law as well. But again, as Oliver says, there's already been very strong guidance from the chief coroner to cut the number of COVID-related inquests to the absolute bare minimum. They're doing that for a variety of reasons, mainly, I think, resources and costs. But I do want to reassure you that the general issues will be dealt with by the public inquiry. And that if there are specific issues, which I know there are in many cases, then you should be asking the local coroner, and where possible, the team will help to have individual inquests. Okay, thank you for that. Everybody, we're getting a lot of questions, so thank you for that. Just to reassure you, I'm probably going to jump off these popular Q&As. Just because I want to give enough of this session over to the individual ones. I do want to just ask the panel, before I go on to the individual questions, a couple of quick ones. Pete, can you tell us just quickly why there should be devolved inquiries? Right. Is that something you can answer pretty succinctly? Absolutely, yeah. Well, a key question, because obviously, you know, we have the UK and then we have 4 countries within the UK, and we have regrettably large numbers of families from all 4 of the nations, and so we have encouraged the formation of groups in Scotland, Wales, and Northern Ireland, or subgroups in those 3 areas, for the purpose of looking at devolved questions or devolved matters. And we're discussing with the families. The Scottish group has already decided, and we've advised, and we agree with this, is that we should support a UK-wide inquiry, but also a complementary Scottish inquiry, which will deal with devolved matters. So the UK-wide matters affecting Scotland will be dealt with in the main UK-wide inquest, and then the devolved matters would be dealt with in the Scottish inquiry. And the discussions are ongoing with the Welsh families. Now, it looks very likely that the Welsh families will decide likewise. And we've yet to speak to the Northern Irish families. We're also inviting other human rights solicitors to assist us in those areas. And 3 firms, one in Scotland, one in Wales, and one in Northern Ireland, are being instructed, as well as Elkan's firm, to assist with the devolved matters there. So that's the purpose. So what we're advising, and what the families that have looked at this so far are instructing us, is to support a UK-wide inquiry, but also complementary inquiries in Scotland, Wales, and Northern Ireland, to look at the devolved decisions and the devolved issues that have arisen. Great. I can speak more about this, but that's a summary. There's clearly a lot to get through here. So last one to the panel for now. Kate, I'm going to come to yours if that's okay. So will the fact that there were different guidelines in each of those devolved administrations have any impact on the inquiry?
Yes, thanks, Andrew, and good evening, everyone, from me as well. I think the short answer is probably it's probably implicit in what Pete has just been talking about, but the short answer would be that yes. The inquiry should look at the measures in place to address the pandemic and how they were devised and implemented, and their effectiveness. So where there were different guidelines in place, the inquiry would need to consider the rationale for that, the evidence underlying those guidelines, why they varied, and also then go on to look at their effectiveness. So it should look at the decision making effectively of all the relevant state bodies, and that would include devolved administrations. But going back to what Pete's just been saying, I think the way that is done will depend on the form of the inquiry. So whether there is a UK-wide inquiry, whether there are devolved inquiries, or whether there are both.
Great. Okay, thank you for that. Okay, I might come back to those FAQs later, panel. So I know there's still 2 on there. One that's coming up a lot in the chat is whether what can individuals do to support the work of the legal team? We've had about 6 people ask that question. So what can individuals who are on this call, or individuals that are members of the group, do to support your work? Elkan, who should that go to?
Shall I kick off, and then maybe other people can pick it up?
Yeah.
On the legal front, where people have asked me, I've said, try and set down your recollections as soon as you feel comfortable doing it. The sooner you do it, the more accurate it's likely to be. At the same time, I realise how upsetting it can be. So you have to decide when the best time for you is to do that. On the non-legal front, it's a matter of what the COVID bereaved group can do, and you can play a part in that group. I think the next stage in their campaign is asking people to write to their local MPs. So we, the lawyers, are not coordinating the campaign of the COVID bereaved group. So any assistance you can give on that front has to be through them, although we know about it, of course, and are liaising with them. But I think it needs to be through that group to be fully effective. Does anyone want to add to that?
Yeah, just picking that up and running with that. I mean, our role is very much to support you, and through you, the campaign. The campaign has done fantastic work. We've assisted as much as we can. We discuss with the families who've been leading the campaign and the campaign workers on a regular basis how we can work together. And when we write to the government, very often, or argue with the government, very often we've got an eye to providing that material to the campaign so they can take that forward. So, I've been saying right from the off that the legal team cannot get what you want on its own. This is a joint effort, and the campaign must get public support, political support, and we must take the arguments to the government and try and progress through legal routes. And Elkan's right. The more people get involved in the campaign, the better. Take your lead the campaign. At the moment, writing to your MP and saying to your MP, look, why has this gone cold? Why isn't the inquiry being properly formulated now? Why are we having to wait? Why is there further delay? That kind of thing. That's what's massively important at the moment.
Okay. Thanks very much, Pete. Forgive me, panel. I'm reading so many questions here. I'm not necessarily listening to all your answers in detail. So if I ask you a question that's all you've already answered, please just tell me and I'll move on to the next question. We've got plenty to go at. This is quite a common one. Could the outcome of the inquiry lead to a criminal prosecution? And as a kind of follow-up to that, will we be suing anybody for compensation as a result of this? So kind of two questions in one there. Could the inquiry lead to a criminal prosecution, and will we be suing anybody as part of this? Yeah,
I mean, as Elkan said earlier, an inquiry cannot determine either criminal or civil liability. So the answer on that level is no. But the real answer is much more complicated, because the inquiry brings out all of the material and all of the evidence, and conclusions are reached, and very much that informs the other processes. So the police and the prosecuting authorities will be watching closely the inquiry, and the outcome of the inquiry often has, as a matter of law, to be considered by prosecuting authorities. So if you take the Hillsborough inquests, as they were, but they were kind of a public inquiry by another name, the jury concluded in Hillsborough that the deceased had been unlawfully killed, and then following from that there were criminal prosecutions. So that's an example of what happened there. And likewise, as a matter of public record, again in Hillsborough, but other matters, there were follow-on civil proceedings where people managed to gain compensation, but they are separate processes. And no doubt Elkan will be happy to engage with families and groups of families on both of those issues as well.
Great, thank you. This has come up quite a bit, quite questions about hospital-acquired COVID. So what will be done about those who died from hospital-acquired COVID? Will a separate group be set up to deal with this as per care homes?
Again, I'm happy to answer that. I mean, we actually discussed this very point earlier on. Until we know how the inquiry looks, we don't precisely know how it will run. It may well be that the inquiry has different modules. So there'll be a part of the inquiry dealing with care homes and other congregate facilities. There'll be a part of the inquiry dealing with hospital-acquired infections, but we don't yet know that. And so there are obviously both overlapping but separate issues that arise from each of these. So it's a bit early to say how that will happen. I mean, in some cases, people obviously don't precisely know where their loved one contracted the infection, and therefore they will have overlap anyway. And of course, there is the transfers between care homes and hospitals, which is a very key issue as well. So I'm sorry to I'm being a bloody lawyer and dodging the actual question, but it is a bit too early to say. But we will be looking at each of these issues both separately and together as they join up, and with the families that are involved in those. So you can rest assured that that's what will happen.
Great, thank you. So I can see quite a lot of questions coming to the panel in the chat. Can I just ask people if you can get those into the Q&As for me? We are picking up everything from the Q&As. It's becoming clear there's a lot of interaction with this, and it's going to help us out just to make sure that your question is answered, and everything that is in the Q&As where you're asking a Q&A will be answered. We are trying to get across the chat, but there's a lot going on that as well. So I'd appreciate it if you can put them in the Q&As. Another question for you guys. This is quite interesting, actually. Recently, 111 Northwest Service have admitted to failings in the case of the father of this attendee. The head of 111 have now said they will stand up in court and admit failings due to guidelines that were not being properly placed by the NHS and the government. Could the families use this admission and take this further?
Yes, is the short answer, and we've specifically included the 111 service and indeed the 999 service in the draft terms of reference that we put forward to the government. So the answer is very much so.
Okay.
And can I add to that? Because it depends on the use to which the family wants that information to be put. Some families may not want their details made public. So, but if the family is prepared for their details to be made public, that's the kind of information that the press would be very interested in. They'd be interested in it anonymously as well, but less interested. They like to have names and families to sort of hang stories on, unfortunately. So as speaking to that person, if they want to pass on that information to us and at the same time let us know the degree to which they'd be prepared to be involved in making that information public at this stage, I think that could be very useful information for possibly even putting pressure on the government to expedite, but certainly something that would need to be explored during the inquiry.
Okay, thank you. Now we've got a lot of questions coming in about timings. I'm going to read you one and then a couple of follow-ups. So the infected blood inquiry has taken years. Will this inquiry take years and years, as we never got justice? This from this questioner for their relative who received infected blood that caused serious medical problems. Just bear with me. When will the inquiry report its findings? Will there be interim reports? And how long can an inquiry take? Can no one be held accountable? Oh, right. So how long can an inquiry take? So can we get a few minutes just on timings of this?
The depressing side of the answer to this is that, you know, Hillsborough took best part of 30 years. Other inquiries, infected blood, possibly longer in many cases. So that's why at the outset, when I was talking about what we've been demanding from the government, is that we're not only talking about timetable, we're talking about time scale. So what we propose to the government is there needs to be a discussion about how quickly the inquiry can be done. Of course, we want no stone left unturned, but if you throw a bit of resources at it, there's no reason why this sort of inquiry should take 5 years or 10 years or however long some of the other inquiries that we all know about have and are taking. The longer it takes, the less justice that you will get, and the less force there are in any recommendations that are made. That you, not only do you want to know what precisely did happen and who was accountable for it and bring those people to book for it, but you also want to know that this can't happen to somebody else in the future, or another pandemic striking, or another manifestation of this pandemic will be dealt with in a different way. So that's why we're so focused on what Johnson means by the inquiry starting next spring. We don't want him to start thinking about it next spring. We want him to start and put the resources in place now, and we want him to discuss with us how quickly the whole inquiry can be done. So it's a really important question, and I hope that provides some answer. But until Johnson and the government start talking to us properly, we're not in a position to actually answer that, beyond saying that an inquiry will take as long as it's allowed to take, and we will shorten it to the utmost within the parameters of not leaving any stone unturned.
Great, thanks, Pete. Elkan, who on the panel could answer this? Is quite a general one. Will any family members be able to speak at the inquiry?
Kate, do you want to deal with that? Oops.
Oh, she's just gone.
I scared her off, I think, there.
That didn't work. Katie, still there? Oh, you're back. She's back. Kate,
Sorry.
I'll throw this one to you. No worries. Will any family members be able to speak at the inquiry?
I would hope so, is the answer. It would be a defiance of all the proper principles that should be applied about putting that we've talked about putting families and the bereaved at the heart of the process. If that were not able to happen, I suppose it would be ultimately for the panel to determine how that process would be done, but that would certainly be after a lot of work and submissions made on behalf of the bereaved by us as a legal team, to make sure that happens in the way that families, in the best way for families.
Right, thank you.
Can I just add to that, because I just saw someone on chat saying, would I need to give evidence? No one would have, well, in theory, the chair has the panel has the power to force someone to give evidence, but in practice, as far as bereaved are concerned, I can't see anyone having to give evidence. And the way I see it working is that the chair, will decide how he or she will look into particular general issues, and the evidence of bereaved families will first of all be considered in the light of whether it can contribute to those issues. So you might give evidence because the evidence is directly relevant to the issues. There's a second question, which is the right of bereaved families to tell their stories. And I think that's very important. It's something we really have to stress. Obviously, 150 or 200,000 people can't all give oral evidence at a hearing. It would just go on forever. So one of the things we and the inquiry will have to think about is, how do we encompass and encapsulate the evidence of every bereaved family in a way that is manageable for the inquiry but accessible to everyone? And there are ways of doing that. It could be a book, it could be video records, it could be a digital record. So there are lots of possibilities, and this is one of the things that I think we would want to discuss with the chair when he or she is appointed.
Okay, thank you. Okay, we've got 5 minutes left. I am going to finish this at 6 o'clock. Just to say, we've now got well over 60 questions. So just to reassure you, if there's any questions that we haven't answered as part of this in the live session, we will be coming back and doing those for you separately. There's quite a few people with personal questions in there as well, and we'll definitely come back on those. There's some quite long and complicated ones that we're certainly not going to have to get time to here. There's some interesting, this is quite an interesting one, Elkan. Who can you choose for this one? Are there any pitfalls to avoid when talking to the media so as not to jeopardize any future legal action?
I think you'd be doing really well if you could jeopardize future legal action. So I think you're all right on that front, but it's more a question of whether what you say is in accordance with the strategy that the COVID bereaved families want to pursue, which is at the moment a strategy of trying to bring the inquiry forward. And I think that's the main point that we would be asking everyone to pursue. Having said that, you each have the right, of course, to say exactly what you want, and to an extent tell us to say what you want us to say on your behalf. So there's an individual decision to be taken as well as a group decision.
Okay. Another one here. If the inquiry makes recommendations, are they obligatory, or could those recommendations be ignored?
They're not obligatory, sadly, and this is a real problem with statutory inquiries, that reviews of statutory inquiries find so many cases where recommendations have been made and ignored. And I don't know if any of the barristers want to add to that.
The last inquiry I finished, the first recommendation I asked the chair to make was that there should be a body to enforce recommendations. And of course, recommendations aren't necessarily right. So it is correct that people should be able to say, well, we can't follow that recommendation because, or indeed sometimes we've got a better idea than that. But chairs are recognising increasingly the problem of coming up with well-reasoned recommendations which are then ignored. So both coroners in inquests and also chairs in public inquiries are developing devices to deal with this. Someone earlier asked whether there could be interim reports. Absolutely is the answer to that. And there have been historically inquiries where there have been interim reports. The Manchester Arena inquiry, which Elkan mentioned earlier, there has just been volume 1. The chair is going to do the report in 3 volumes. He's doing it that way because he made recommendations in volume 1. And he says that later on in the inquiry, whilst he's hearing evidence about other things, he's going to come back and he's going to ask the people who are the subject to the recommendations, and in that case, the government and private security people, he's going to ask them what they've done about the recommendations. So he's putting their feet to the fire. So it's not straightforward, but there are ways of doing it, and people are becoming much, much more interested in enforcing recommendations, because frankly, what's the point otherwise? So that's the answer. So we're very much onto that. It's a great question, and certainly something that we will pursue.
Great, thank you very much. Okay, we've just got a minute to go, guys. This may frustrate some of you, and I'm very sorry about that, but I do want to keep this to this timing for the time being. Thank you for your questions. There are 60. There are over 70 questions, some of which have been repeated, but there are 70 questions. To the person that asked, will the questions that were asked in advance be answered? Yes, those will. Those questions, any questions you sent in advance of this, no need to put them in this Q&A. We will pick those up and we will answer those as well. We've clearly had a very robust response to this live format. Over 85 people were on here at one point, and nearly 80 of you have stayed for all of it. So we can see this first look looks like it is popular. So can I just ask you, everybody on here, just keep an eye out for those questions coming back in. If you've had any personal questions you put in there, those will be answered. Keep an eye on the Q&A on the website. We will make those links, front those up for you so you can see those. There will be the recording of this will be edited to make sure there's no personal information in there, and then that will be made available online. And don't forget, please do just answer that questionnaire that you're going to get when we shut this down, and let us know what you thought of this. Do you think we should run this for longer? Do you think we should do this differently? Please tell us what you guys think. We want to make this as useful as we can for you, and tell us if you like the live format, or if you prefer, really send your questions in and just have them answered on a Q&A on the website. Please do tell us what you think. And if you decide that you'd like another one of these, we will certainly try and run it. We've got a lot of learnings coming out of this, and thank you for your engagement as attendees. Elkan, do you want to just thank the panel and sign off for us?
Yeah, thanks everyone. And it is, I mean, this has been quite an interesting experiment, frankly, for us as well. And if it's something you'd like us to repeat, we'd be very happy to do this. We want to provide you the information you need in the most accessible format for you. So we'll wait to hear from you, I think, now. Yeah,
absolutely. So Oliver, Elkan, Kate, Pete, thank you very much indeed. Thanks everybody for coming along. We've kept it to the 1 hour exactly as we said. We're going to leave you now, and subject to your answers in the questionnaire, we will look forward perhaps to seeing you later. Thanks everybody.
Thanks. Bye.
Bye.